Good afternoon, everyone. I hope you all are doing well this afternoon.
Good afternoon, Your Honor.
Good afternoon, Judge.
Good afternoon, everyone. Ms. Bridgewater, when is the SAP reset date?
It's going to be March the 7th.
Thank you.
Mhm.
All right. Good afternoon, courtroom two. Hope you all are well this afternoon, whenever you all are ready.
Your Honor, this is Ms. Hogue.
Yes, good
And-
afternoon, Ms. Hogue.
Good afternoon. I'm just letting you know I will be requesting a breakout for positions 1, 3, and 12.
Thank you.
Good afternoon, Judge Morrow. How you doing?
I'm doing well. I hope you are as well.
Yeah, today's Monday.
And it's a holiday. So.
Yes, exactly. We have Alpharetta Gerald. They can go first. I believe his position is, name is Mr. Bennett, position 2.
Okay.
And Your Honor, I'm position two for Mr. Bennett. I just have a question. Is the Spanish interpreter on? We've got some cases that do require that. I just want to make sure that we do have the Spanish interpreter coming or on.
Okay. Let's see. Ms. Bridgewater, have you heard anything about requesting? I'm not sure. Oh, Ms. Champion. Good afternoon, Ms. Champion.
Good afternoon, Judge. She's logging on now.
Thank you.
Okay. Very good.
And Your Honor, from the ACDC, good afternoon, Your Honor.
Good afternoon.
Ms. Heyman,
Hold on, Ms. Milton. We're gonna let Alpharetta Gerald go first.
I know, I just wanted to inquire about Ms. Heyman. She's not on the court calendar. I just need to know what's going on with that.
Okay.
Your Honor, this is Jordan Reiser on behalf of the state. Ms. Heyman's case was NOD this morning, and I related that NOD form to the jail this morning through Odyssey.
So that means she don't have to come before the Judge Morrow?
Correct.
Okay, thank you.
Okay. All right. So.
Good morning.
I don't.
Good afternoon. Good afternoon, Your Honor. I'm sorry. Can I just follow up with Ms. Reiser? Ms. Reiser, we did relate it so that the jail will show that the charge is gone. Okay, so there should be no hold on her. I just wanted to make certain we had done it that way, Judge. Thank you.
Okay, very good. Good afternoon.
Thank you, Your Honor.
I don't see the Alpharetta jail. Am I missing them?
There.
Oh, Mr. Bennett, yeah, they're right there.
Oh,
Alfred.
right. Okay. Yes. Yes. If you all will unmute for me. Alpharetta jail, are you all ready? Is there anyone facilitating at the Alpharetta jail?
Hey, Mr. Bennett, if you can hear us, can you ask them to unmute?
Okay.
I'm unmuted.
All right. And is this Fahim Bennett?
Yes, sir.
Yes, good afternoon, Mr. Bennett. I'm Judge Eric Morrow. This is the state court expedited accusation calendar that we're conducting by video. Do you agree to have your case heard by video?
Yes, sir.
Thank you. Mr. Bennett, you've been charged in case 22 CR 000973G with giving false information to law enforcement officer, possession and use of drug-related objects, and possession of marijuana less than an ounce. Is there a history? Who do we have on for pretrial?
Good morning or good afternoon.
Afternoon, Ms. Roberts.
He has 7 cycles, 2 criminal trespass convictions in 2020, a willful obstruction of a law enforcement officer conviction in 2019, battery, family violence, and disorderly conduct conviction in 2016, and 1 probation violation, and nothing further.
Ms. Reiser?
Yes, Your Honor. In regards to the count of false name, the defendant's bond is currently set at 1,000 surety. Into count 2, possession of drug objects, it's currently set at $2,000 surety, and possession under an ounce is currently set at $1,000 surety, making that a $4,000 surety. I would ask that the bond remain as set with the included conditions: no drugs, alcohol, weapons while out on bond. Your Honor, this incident happened. Officer Maloney of the Alpharetta Police Department responded to a residence in regards to a dispute call. When he got there, all parties were separated. When he went to ask the defendant's information, the defendant gave him a false name and a false date of birth. The defendant then admitted to the officer to giving that false information because he thought he had a warrant out. When he was arrested, he was found with 2.7 grams of marijuana in a smoking pipe, Judge. Based on the facts and the history, I would ask the bond remain set at 4,000 surety.
Okay. I'm gonna change the surety bond amounts to a signature bond. So it's going to be $1,000 signature bond for the false information, $2,000 for the object, drug-related object, $1,000 for the marijuana. So $4,000 signature bond through the jail, no drugs, alcohol, or weapons while out on bond. Does that suit you, Ms. Helen?
It does. I wanted to give a great defense for Mr. Bennett, but I believe that suits him, Judge. Thank you.
All right. Good luck to you, Mr. Bennett.
Thank you.
Who do we have next?
Position 18, Shealy.
That's my position, Judge.
Okay.
Okay.
And this is Sky Shealy, is that right?
That's correct, Judge.
Yes, good afternoon. I'm Judge Eric Morrow. This is the State Court Expedited Accusation Calendar that we are conducting by video. Do you agree to have your case heard by video?
Yes.
Thank you. You have been charged in case 23 CR 000989G with battery and theft by taking. Is there a history, Ms. Roberts?
I'm showing this being her first arrest.
Thank you. Ms. Right, Ms. McCutcheon?
Yes, Your Honor. This defendant is charged with battery and theft by taking. The state would expect the evidence to show that on the incident date, February 18th of this year, at the IHOP located at 2510 Flat Shoals Road, the defendant responded to that location. She had a physical altercation with a former employee. Ms. Gomez, who was a victim, advised that the defendant came to the location. She was a former employee. She became involved in a physical confrontation with the victim, struck Ms. Gomez, the victim, several times, leaving her with a visibly busted bottom lip with a small laceration. She then stole the phone of the second victim, Mr. or Ms. Jahani, iPhone, and fled the scene. For the battery, Your Honor, the state concurs with the first pretrial's recitation of the criminal history. The state would recommend for the bond a $3,000 surety bond on the battery, theft by taking a $1,000 good bond for a total $4,000 good bond. No contact whatsoever with Valerie, Valery, middle name Huert as in Tom A, Gomez, normal spelling Gomez. Additionally, no contact with Kimberly, Kymberli, last name Johnson, also a witness at the IHOP during this incident. And lastly, no further contact at all with Jahani, the second victim, Jahani, last name Johnson, and to stay away from the IHOP located at 2510 Flat Shoals Road in Fulton County.
Ms. Helen?
Yes, Judge. Miss Shealy is currently 19 years old, Judge. She was employed, making honestly a substantial amount from Amazon due to recent employee cuts. She has been unemployed for the last several weeks. She is a high school graduate of Benjamin Banneker High School. Judge, she was a lifetime resident born in Clayton County, Judge. She doesn't have any children, Judge. However, from that high school degree, Judge, she wants to pursue her college career at Atlanta Metro College, seeking a degree in psychology. For this particular incident, Judge, Miss Shealy, it is her first arrest. She understands the seriousness of the situation, but Judge, we are asking for a signature bond for both cases, Judge. For the battery, no more than $1,500 signature bond, and the theft by taking, no more than $500. When I spoke to Miss Shealy, she is trying to get back into school. She's trying to refocus her life, and in this particular circumstance, she actually had a previous interaction with Miss Gomez, where Miss Gomez offered her violence. And at this time, Miss Shealy's partner worked at the IHOP. And I believe you read the warrant. Miss Gomez was at that IHOP because she works there, but also her boyfriend. And so Miss Gomez and her boyfriend physically went up to Miss Shealy, and she wanted to protect herself. She does not have a history of being a long, violent offender, Judge. So we are asking for that signature bond.
Great. Given that this is Ms. Shealy's first arrest, it's going to be a $3,000 signature bond through pre-trial per the judge for the battery, $1,000 signature bond through pre-trial per the judge for the theft by taking, which makes for a total of a $4,000 signature bond through pre-trial per the judge. 1-day anger awareness, no further contact with Ms. Gomez, Ms. Johnson, or I think it's Mr. or Jahani Johnson also. Stay away from the IHOP located at 2510 Flat Shoals Road, and no drugs, alcohol, or weapons while out on bond.
And
Ms. Shealy,
I apologize for interrupting you, Judge. Miss Shealy does state she would like to have contact with Miss Johnson, who's her current partner, who she was visiting at the IHOP. She would like to have contact with that current girlfriend.
okay, has anyone spoken with that alleged victim? And if not, then there's not going to be any contact, Ms. Helen, as is normally this court's procedure.
And Your Honor, the state has had no successful contact today with that victim, with that witness.
Okay, until there's some type of contact, Ms. Helen, there's going to be a stay away. If she seeks something different in the future, of course, she can seek to have that modified. Ms. Shealy, although I am allowing you to have a signature bond, if you do not attend your next court hearing, they will put a warrant out for you, and you'll be right back where you are, okay?
Okay, thank you so much.
All right, good luck to you, ma'am.
Position 17, Ms. Roberts.
I believe Ms. Roberts is, if it's Joletta Roberts, I have her as position 16 on my calendar.
Yes, correct, Your Honor.
Okay.
I apologize.
No, you're fine. I just want to make sure. Ms. Roberts, good afternoon. I'm Judge Eric Morrow. This is the state court expedited accusation calendar that we're conducting by video. Do you agree to have your case heard by video?
Yes, ma'am. I mean, yes, sir. I'm sorry.
You're fine, Ms. Roberts. You've been charged in case 23 CR 0009878 with battery family violence. Is there a history pre-trial?
I'm showing 4 cycles, 1 out of Georgia, 3 out of North Carolina. Showing a 2015 conviction out of North Carolina for a common law forgery, a 2014 conviction for simple assault out of North Carolina, along with soliciting, obtaining false pretense. Then I'm showing an arrest from January 24th, 2022 for battery family violence out of Georgia. There's no disposition listed. And nothing further.
I don't know who's speaking, but we can, I'm not sure if that's the, okay, maybe it's Alpharetta. Ms. McCutcheon?
Yes, Your Honor. Additionally, the defendant has a false imprisonment. That January 24th, 2022 case, it's also a charge of false imprisonment. That is pending in the District Attorney in Superior Court. That case number is 22 CP 206075, and it involves the same victim as the victim in the instant case, Judge. That victim being Khadija, Khadija, last name Grissett, Grissett. In the instant case, Your Honor, on the alleged incident date of February the 10th of this year at the location of 2100 DeForest Ferry Road, apartment 2060 in Atlanta, Fulton County, the officer arrived on the scene, made contact with the victim. The victim stated that Ms. Roberts and she had been in a relationship for 5 years, living together in the state of Georgia for 2 years. She had visible injuries that she reported to the officer she had sustained as a result of the defendant grabbing her by the hair, throwing her to the ground, stomping, kicking, biting, and scratching her. The officer observed highly visible, penetrating bite mark to the front of her right forearm, lacerations that were covered in dried blood. The victim reported that the defendant was biting her everywhere, as she stated to the officer. She also had sustained small lacerations to her arm. The officer suspected those of having been caused by fingernails during the scuffle. At some time, the victim, during this altercation, the victim reported to the officer that she tried to flee the scene by breaking a bedroom window and trying to exit. But as she was trying to get out of that window, the defendant forcibly pushed her, causing some of the broken glass to result in further injuries and lacerations on the right side of Ms. Grissett's torso, which were also highly visible and covered in dried blood, according to the officer. And lastly, she had minor bruising below her right eye, Judge, and a long, thin laceration to the back of her left arm, also covered in blood. Judge, based on the significant injuries that this victim sustained, and also in light of the fact that she has an incident from a year ago involving the same victim with a family violence and additionally a felony false imprisonment. The state is recommending to the court that the defendant be issued a bond in the amount of $10,000 cash, or if the court is not inclined to order a cash bond, that the bond be no less than $20,000 good bond, Your Honor. The defendant has a current $5,000 bond on the false imprisonment. I submit to the court it's obvious that the defendant does not intend to adhere to the court's orders. Notwithstanding that $5,000 bond, here she is a year later before this court again with another family violence case against this same victim. So we would ask, Judge, that the bond be no less than a $10,000 cash or $20,000 surety, that the defendant have no further contact whatsoever with Ms. Khadijah Grissett, that she stay away from the incident location, which was the 2100 DeForest Ferry Road, apartment 2060, Atlanta, Fulton County, that she also possess no weapons and consume no alcohol or illegal drugs while on bond.
Ms. McCutcheon, in that false imprisonment bond, was there a stay away, do you know?
Yes, Judge, and the bond condition included no further contact and a stay away. And I'll just say on the record, Judge, that the state is considering looking at this case and sending it this week, tomorrow, to the district attorney's office to look at for a possible aggravated stalking offense. But as it is today, it is still before this court.
Thank you. Ms. McLeod, good afternoon.
Good afternoon, Your Honor. My client is 31 years old. Your Honor, I would just like to clarify some of the things that were said. There was a stay away in the first incident between parties, Your Honor, and the alleged victim had moved. They had not been in contact for this entire year. My client tells me that the lease was coming up to be ended anytime now. She was the lessor, and unbeknownst to her, that the alleged victim, who still had a key, came over to the apartment saying that she wanted to move some of her stuff out. So it was not that my client initiated any kind of contact. My client doesn't even have any contact information for her. She doesn't have a phone number. She doesn't know where she lives. She said she just showed up at her place. And of course, naturally, they got into an argument. She didn't come with law enforcement or anything, because apparently she had things there from the initial incident. But my client denies that they were actually in contact during this time period because of the bond conditions that were initially set. So I just wanted to set the record straight on that, Your Honor, that they were not actually living together in that first incident.
Okay, so while you're clarifying, Ms. McLeod, I want to make sure that I'm understanding what you're saying. The 2100 DeForest Ferry Road address, is that the address that this incident that we're here for today occurred at?
That is where it occurred, Your Honor.
Okay. Is that the address that the previous bond for the false imprisonment has Mrs. Roberts staying away from?
Yes, Your Honor. I think so. I'm not sure. I think it was one of them. They were not to have any further contact, and the alleged victim was the one who left.
Okay, well, I'm trying to just understand that, because if the underlying false imprisonment bond says for Ms. Roberts to stay away from the DeForest Ferry Road, and that bond has not been modified, I don't understand why she would have been there.
Your Honor, my understanding, and I have not seen the bond, but what my client tells me, it was that they were not to have any further contact, and the alleged victim was the one who moved, and she remained at this location.
Okay. Well, my issue with that is that, you know, so that there's no misunderstanding, that bond should be modified to allow her to go back there. As long as there's a bond that says she can't go somewhere, then she shouldn't be at that place, right?
I'm thinking that what she's telling me is that her understanding was that it was that they should not have any further contact, and the alleged victim moved.
Okay.
Judge, yes, Judge, respectfully, I'm looking at the bond now, the bond that it's in Odyssey under this 22 CP number. And that's the case that I just quoted to the court before. The bond was set on January the 27th of 2022, and 22 CP 206075 for one count of false imprisonment is set by Judge Wolf. The special condition is that the defendant must adhere to the following: no weapons/firearms, stay away from 2100 DeForest Ferry Road, Atlanta, Georgia, may return one time to location with law enforcement to retrieve property. So the state would submit to the court that the defendant, unless this bond had been modified, the defendant had no authority, according to this court, to be at that location of 2100 DeForest Ferry Road where the instant case occurred.
Okay. All right, you can continue, Ms. McLeod.
Yes, Your Honor, my client is employed, yes. Has been employed, gainfully employed. She tells me she works for FedEx. And she denies that she was the primary aggressor in this case, Your Honor. She also tells me that she is moving because the lease is now up on this particular property. So there is no issue with her staying away from there in that she plans to move. But of course, she doesn't have her belongings there, Your Honor, and she would like to be able to retrieve her belongings. I would ask the court to give my client a reasonable bond so she can get out of jail. She denies that there is any ongoing relationship with her and the alleged victim, Your Honor, and that this incident was caused by the alleged victim showing up to her, to where she lives unannounced. Nothing further, Your Honor.
Okay. I don't think that she should have been at the DeForest Ferry Road address per the previous order. So I think she's in violation of that previous order. As such, it's going to be a $10,000 surety bond. No further contact with Ms. Grissett. Stay away from the DeForest Ferry Road apartment 2060 address. She can go back to that address on one occasion with law enforcement to retrieve any belongings that she might have there, and no drugs, alcohol, or weapons while out on bond. All right, good luck to you, Ms. Roberts.
Position 1, Abdul Ali.
How many interpreter cases are we going to have this afternoon? Do we know? And when you all are if you have a separate room that you're gonna, I'm not sure if counsel needs to have a discussion with their clients prior to a hearing, but I want to make sure that we're setting all that up.
Yes, we have one, that's gonna be for Mr. Holber, position 20, and the
Okay.
other one got upgraded. The other Spanish interpreter case got upgraded to a felony.
Okay, and who's representing? Is that you, Ms. Hogue, that's representing?
No, Your Honor, that's me.
Oh, Ms. Helen, and have you spoken with your client?
No, Judge, I need to speak to Mr. Tovar Garcia.
Okay, so
Judge Morrow, Officer Norris is gonna go to courtroom 3.
okay, all right, very good. Thank you. I just wanted to make sure that that was in the work, so I appreciate it.
Thank you, Judge.
All right, let's see. And Madam Interpreter, good afternoon. Thank you for joining us as always. We appreciate it. Thank you.
You're welcome, sir.
And this is Mr. Abdul Ali, is that correct?
Yes.
Yes,
And
good
yes.
afternoon.
Your Honor, I requested a breakout for MH issues.
Oh, okay, very good. So let's have a breakout with Ms. Hogue, Ms. McCutcheon,
Can I
Ms.
do it too,
Weiser.
Judge?
Yes, of course, Ms. Helen and Ms. Bridgewater. Anyone else?
That'd be it.
And what I would like to do is I would like to discuss all the positions while we're in the breakout room. I believe that's 1, 3, and 12. Ms. Hogue has spoken with me about if there are any other positions where we need a breakout room. Can we just?
Yeah, no, Your Honor, I mentioned 3 because originally I interviewed Mr. Clark. It turns out that Mr. Clark is now represented by Brian Tevis. So I will let Mr. Tevis ask, and
Okay, all right.
found out
So-
whether he wants a breakout.
And Judge, on position 3, Mr. Clark, I would like to have Mr. Tevis join us in the breakout room just to discuss some of the facts of the case.
Okay, that's fine. That's a good afternoon, Mr. Tevis. So let's go ahead and do that now so that we get all the ones that need a breakout room disposed of. Okay?
Okay.
Hey, Ms. Champion,
Yes.
can you put courtroom 3 and the Spanish interpreter in the breakout room, and then when Miss Helen comes, you're gonna put her in the breakout room with us?
Okay, I'll go ahead and do it.
Thank you.
Okay, we are back. We've had the occasion to speak on a number of cases, so thank you for your patience with this courtroom too. For Mr. Abdul Ali, Mr. Ali, I've had the opportunity to speak with your counsel, and the state in this regard, the bond is going to remain where it is, a $2,500 good bond. No further contact with Ms. Hernandez, and stay away from 3276 Northside Parkway. No drugs, alcohol, or weapons while out on bond. Does that cover it, Ms. Hogue, for Mr. Ali?
You're muted, Ms. Hall.
Yes, it does, Your Honor.
Oh,
Okay,
I'm
yes.
sorry, Judge, I forgot to mention also for courtroom 3, the Spanish interpreter, they didn't do the breakout for courtroom 3. Norris just called.
Oh, are we able to do a breakout room in courtroom 3?
Yes,
Okay.
I just put Miss Helen in the breakout with the.
Oh, okay, all right, very good, thank you. Mr. Ali, Ms. Hogue will, I see that you have your hand up there. Ms. Hogue will talk to you and let you know what's going on, okay, after court today.
I'll talk to you, Ms. Ali, after court. I'll be at the jail.
Judge, Your Honor, Your Honor.
Yep, Mr. Ali, hold on. You have a right to remain silent. Anything you say can be used against you. So why don't you let Ms. Hogue do the talking for you, okay? And she'll be able to communicate anything you need to the court, all right? I don't want you to get yourself in any trouble by saying something, okay?
We'll talk later on, Mr. Ali. I'll be at the jail tonight.
Okay.
And Francois, can we go to
Mr. Clark?
position? Yes, please.
Yeah, that's the private attorney case. Go ahead and have a seat.
Yes. Yes, good afternoon, Mr. Clark. I have also had the opportunity to speak with your counsel and the solicitor regarding your bond. For the Lorden and Prowling, it's going to be a $2,500 good bond. For the second misdemeanor charge, it's going to be a $2,500 good bond. And for the obstruction, it's going to be a $1,000 good bond, making for a total of a $6,000 good bond. Stay away from 1112 Bobby Dodd Way. No further contact with the alleged victim, Ms. Varria, I believe, and no drugs, alcohol, or weapons while out on bond. All right. Good luck to you, sir.
Judge, if I can just relay for him that I'm in touch with his family about the bond issue, so he can call me when he gets out. Did you hear me, Mr. Clark?
Yes, sir.
Okay. All right. Thank you.
Thank you. Okay.
All right. Anything further, Mr. Tevis?
Nothing further. Thank you, Judge.
We also have
17. Oh,
And we-
go ahead, Francois.
We also, just so you know, that we also had the opportunity to discuss position number 12, Mr. Jones.
Mr. Jones, 12. Okay,
Is he available?
where's Mr. Jones? Okay, have a seat over here for me.
And yes, good afternoon, Mr. Jones. I'm Judge Eric Morrow. We also had the opportunity to discuss your case while we were in the breakout room. Your bond will be for the 2 simple assaults. It'll be a $750 good bond for each charge. And for the willful obstruction, a $500 good bond, making it a total of a $2,000 good bond. You can still ride MARTA, Mr. Jones, but you cannot go to the MARTA bus station, the one that's at Peachtree and Buckhead Avenue. So you're going to have to go someplace besides that location. You can have no further contact with the bus driver, Miss Coulter. So if she comes along and she's driving one of those buses, you're going to have to take the next bus because you're not to have any contact with her. And I don't know if you know Mr. Cortez Harold, who was an alleged passenger on the bus, but you're not to have any contact with him also. No drugs, alcohol, or weapons while out on bond. Okay? Did I cover everything, Ms. Hogue?
Yes, you did, Your Honor.
Okay, good.
I'll explain it to you.
All right, good luck to you, Mr. Jones.
Mr. Jones, I'll be at the jail tonight to explain everything to you if you don't understand some terms, okay?
Okay.
Thank you.
Welcome. Who do we have next?
Position 17, Ms. Rouse.
Good afternoon, Ms. Rouse. I'm Judge Eric Morrow. This is the state court expedited accusation calendar that we're conducting by video. Do you agree to have your case heard by video?
Good afternoon, and yes, sir.
Thank you. Ms. Rouse, you have been charged in case 23 CR 0000988Y with battery family violence. Is there a history, Ms. Roberts?
I'm showing this as the first arrest.
Okay. Ms. McCutcheon? You're on mute.
I apologize, Your Honor. This is actually a dual arrest. The cross defendant is a Michael Taylor who's charged in 23 CR 0000968, who was seen on the SCA calendar on February the 18th of this year. This case arose out of a dispute that occurred on the incident date as alleged to be February the 17th of 2023 at the location of 1371 Kimberly Way in Atlanta, Fulton County. Officers responded to a dispute at that location. When the officers, there were three, it looks like three officers arrived at the location. They spoke with Ms. Rouse, who said that she had been assaulted by the cross defendant, her boyfriend, Mr. Taylor. He was still on the scene. She had a visible small laceration to her lip and a scratch under her right eye. She stated they did not live together, she and the cross defendant, but he had spent the night a few times at the home. The officer went on to say that the story was not consistent that Ms. Rouse provided. She began by stating the physical dispute occurred in the parking lot at the location, then changed her story to say that the physical dispute occurred inside her apartment. The officers also spoke with the cross defendant, Mr. Taylor, who stated he also affirmed that they had had an altercation. However, he did not admit to being the primary aggressor. Ms. Rouse became very irate. She said, according to Mr. Taylor, and that she had grabbed him. And I will say, Judge, there was a neighbor on the scene who refused to be listed as a witness and wanted to remain anonymous. That male stated that he had witnessed Ms. Rouse run up the stairs after Mr. Taylor, grab his arm, and began to hit him multiple times. The male stated he knows both parties from the apartment complex, but does not know either one of them personally. But as I said, that particular individual wished to remain anonymous and did not give his name to the officer. Because the officer could not determine, because of the inconsistencies and conflicts in the statements, who was the primary aggressor, both were arrested and charged. The state shows that this was in fact the defendant's, or is the defendant's first arrest. The state's bond recommendation, Your Honor, is that, and I make this recommendation, Judge, in light of the fact that the cross defendant received a $3,000 good bond. He's charged with simple battery. This defendant is charged with battery as a result of the cross defendant sustaining visible injuries. Therefore, the state is recommending a $5,000 good bond, no further contact with the cross defendant, Michael Taylor, stay away from the incident location at 1371 Kimberly Way, Atlanta, no drugs, alcohol, and weapons.
Okay, thank you. Ms. McLeod?
Yes, Your Honor. My client is 41 years old, and the Kimberly Avenue address is her home. She lives there. My client is a mother of 4 children ranging in ages from 18 to 30 years old. She is gainfully employed as a nurse, Your Honor, and has absolutely no criminal history. She is also from the Atlanta area. I would ask the court to give my client a signature bond, given her lack of criminal history and the fact that she and the cross defendant do not live together. And she has no problem with him staying away from her residence because this is her residence. And she has absolutely no problem with a no further contact order with the cross defendant. Nothing further, Your Honor.
Okay. Given that this is her first arrest, it's going to be a $3,000 signature bond through pretrial per the judge, 1-day anger awareness, no further contact with Mr. Michael Taylor, no drugs, alcohol, weapons while out on bond. Ms. Rouse, I'm going to give you the opportunity to sign yourself out, but if you don't show back up for your next court hearing, they're going to put a warrant out for you, okay?
Yes, sir.
All right, good luck to you, ma'am.
Thank you.
Thank you, Your Honor. May I be excused, please?
Yes, I'll see you next time. Thank you.
And may I also be excused, Your Honor? This is my
Yes, Ms. McLeod, you have
Gymnast.
the rest of your day.
Thank you.
Position 11, gymnast.
Good afternoon, Mr. Jimenez. I'm Judge Eric Morrow. This is the state court expedited accusation calendar that we're conducting by video. Do you agree to have your case heard by video?
Yes, Your Honor.
Thank you. You have been charged in case 23 CR 0000982D with driving under the influence of alcohol, less safe, willful obstruction of a law enforcement officers, failure to yield the right of way, and driving under the influence of alcohol per se. Is there a history, Ms. Roberts?
I'm showing 7 cycles with 1 conviction from 2022 for DUI and reckless driving. And nothing further.
Thank you. Ms. McCutcheon?
This is actually Ms. Risers, Your Honor.
Oh, okay. I'm sorry, Ms. Reiser.
Yes, Judge, no worries. In regards to the state's recommendation for bond is currently set on the DUI less safe as $2,500 surety. On the obstruction charge, $2,500 surety. The failure to yield, $2,500 surety. The hit and run, $2,500 surety. And I would ask for a $2,500 surety on the DUI per se, making a total bond amount of $12,500. No drugs, alcohol, or weapons while out on bond, and no driving unless permitted by DDS. Judge, the Officer Basco responded to a traffic accident on Holcomb Bridge Road in Fulton County. During that traffic accident, the defendant failed to yield and struck a vehicle. His vehicle then went over an embankment and flipped over. Multiple eyewitnesses on scene pointed the officer towards the defendant, who was running away from the scene when he got out of his car. When Officer Basco finally caught up with the defendant smelled like a strong odor of alcohol, had slurred speech, couldn't stand or walk on his own. He was arrested and read implied consent and agreed on a state blood test, Your Honor. As you heard from pretrial, he does have 7 cycles. I'm showing that DUI was actually reduced to a reckless driving out of 2022. While he doesn't have any other convictions, he does have a 2012 arrest for furnishing or possessing alcohol under the age of 21, which was dismissed, a 2014 possession of marijuana under an ounce that was dismissed, a 2014 battery that was NOD'd, and a 2017 purchase possession of marijuana where he did pretrial diversion, and that was null prost. Judge, given this is a public safety risk and a very huge accident occurred, I think the bond as set at $12,500 is reasonable given these facts and his history of previously being arrested for a DUI and now is a repeat offender.
Ms. Hogue?
Yes, Your Honor. Mr. Jimenez is 27 years old, Your Honor. He's been in this country now for 15 years. His entire family is here. He actually went to high school here, but had to stop because he was working to support his family. He was a young father, Your Honor. He is 27 and he has a 9-year-old daughter who will be 10 soon, as well as he has a baby on the way. He and his wife have been together for 5 years now, married, as well as before that, not as married, but as a couple. And he has a consistent job here. He does delivery service for, I hope I say this right, Mobus Atlanta Peach. He's been doing that for like 3 to 4 years now. So he meets all the IL factors. Additionally, Your Honor, he was approved for an unsecured judicial release, okay, according to pretrial. So first we would ask to go ahead, and since he has been approved, we would ask for that to convert that $1,250 to a signature bond instead. But if the court is not willing to do signature bonds, then we would ask to have all the bonds reduced to $1,000 each, Your Honor, given that he only has a reckless driving, and that's from 2022, which is fairly recent. But beyond that, everything else is a bit older, Your Honor. So we think that $4,000 is more than enough to secure his presence in court, Your Honor. He has no FTAs. He has none of those factors that would be a problem for any type of loan or signature bond.
Okay, for each of the DUIs, the less safe and the per se is going to be a $1,500 good bond. For the other 3 charges, it's going to be $1,000 good bond. That makes for a total of a $6,000 good bond. No drugs, alcohol, or weapons while out on bond. Good luck to you, Mr. Jimenez.
Judge, you said the total is gonna be 6,000 good bond?
Yes, correct.
Thank you.
Thank you, Your Honor.
You're welcome.
Position 10, Hudson.
Good afternoon, Mr. Hudson. I'm Judge Eric Morrow. This is the State Court Expedited Accusation Calendar that we're conducting by video. Do you agree to have your case heard by video?
Yes, sir. Yes, I do.
Thank you, Mr. Hudson. You've been charged in case 23 CR 000981E with battery. Is there a history, Ms. Roberts?
I'm showing 10 cycles, 1 FTA from 2015, 1 probation violation from 2018, 2 DUI convictions, 2013 and 2016, and nothing further.
Judge, the defendant's bond for battery, I believe, is currently set at a $10,000 surety. I would ask that it remain as set with the conditions added, no further contact with Cain, CAIN, Bergeron, BERGERON, no drugs, alcohol, or weapons while out on bond. Officers did respond to the defendant's address at 2120 Argo Drive. They met with the victim, Mr. Bergeron, who stated he was there to check on the defendant, like a welfare check. The defendant was intoxicated and became irate and attacked the victim by scratching him on the cheek and face. Officers did observe visible injuries to the victim. The defendant also took the victim's phone, but the victim did recover that. And in speaking with the defendant, when the officer spoke with the defendant, he also admitted to becoming irate and attacking the victim. In addition to his, like you heard, Judge, his convictions for DUI, he also had 2 other DUI arrests that were, one has no disposition, one was dismissed, and his FTA, Judge. So I believe the bond is set, is reasonable given these facts and his history, Your Honor.
Who is Mr. Bergeron to Mr. Hudson, and have you had an opportunity to speak with him?
I believe that they are friends, and let me just double check. The last time I looked, I don't think that we were able to make contact with Mr. Bergeron. If Ms. Hogue wants to go, and I can update the court once she's.
Okay, thank you. Thank you, Ms. Reiser. Ms. Hogue?
Yes, Your Honor. Mr. Hudson is 46 years old, Your Honor, and he is a member of the Georgia Bar. He's been a lawyer now for 19 years. He attended Morehouse College. He moved to Georgia to go to college here. He attended Morehouse College as well as UGA Law School. He has all his family here as well, and he hails from Washington, D.C., Old Mill High Schools where he graduated from, but he's been here ever since, Your Honor. He and the alleged victim here have a business relationship, Your Honor. So I would say a no further violent contact is more appropriate than a no contact, Your Honor. So, and as far as the bond goes, Your Honor, I believe that even though he does have history, it is not related to this type of offense, Your Honor. And the FTA is from 2015, if I heard correctly, it was breaking up, which we're looking at 8 years ago. So I believe, Your Honor, a $2,000 bond, good bond, is more than ample to assure he shows up. I'm sure he will be here, Your Honor. That will be not a problem. And he intends to address these issues without question.
And I heard something about a welfare check. And I'm just really, you say he has a business relationship with Mr. Bergeron. Apparently, Mr. Bergeron was concerned enough to go check on him for some reason. I'm just trying to figure out what the nature of that is.
Judge, do you want to go to a quick breakout room?
That would be better.
Okay, all
Yes,
right.
we could go to a breakout room very quickly.
Okay, that's fine. I think that would help me make a decision.
Yeah.
So if you can put Ms. Reiser, Ms. Hogue, Ms. McCutcheon, Ms. Bridgewater, myself into a breakout room, please. Okay, yes, Mr. Hudson, we've had an opportunity to discuss your matter. It's going to be a $2,000 good bond, no further violent contact with Mr. Kane Bergeron, and no drugs, alcohol, or weapons while out on bond. Good luck to you, sir.
Thank you, Your Honor.
You're welcome.
Position 9, Gullen.
Good afternoon. I'm Judge Eric Morrow. This is the state court expedited accusation calendar that we are conducting by video. Do you agree to have your case heard by video, Mr. Gullen?
Yes, Your Honor.
Thank you. You've been charged in case 23 CR 000979G with criminal trespass. Is there a history, Ms. Roberts?
I'm showing 31 cycles. 31 cycles. I'm showing a total of 8 probation violations, 3 FTAs, 2016, 2 in 2017. I'm showing an arrest out of Cobb County from August of 2022 for willful obstruction of a law enforcement officer, driving while license suspended, and fleeing or attempting to elude. There's no disposition listed. That case appears to be open. A 2017 conviction for a felon to register. A 2017 conviction for possession of marijuana less than an ounce. The underlying charge for the 2017 conviction was in 2012. A 2013 conviction for theft by receiving stolen property. 2011 theft by shoplifting conviction, and then 2009 theft by deception and theft by receiving stolen property. And nothing further to add.
Yes, Judge, I would agree with that recitation of the criminal history, the 31 cycles, multiple convictions, multiple FTAs, multiple VOPs. The defendant's bond is for criminal trespass is currently set at $1,500 surety. I would ask that it remain as set, nothing lower than $1,500 surety. And I would also ask for a stay away from 1105 Holcomb Bridge Road and 9995 Old Dogwood Road. Both of those locations, this defendant has been previously criminally trespassed from. The Holcomb Bridge Road is an Exxon service station, and the Dogwood Road is the Economy Hotel. Officers did respond to that Exxon gas station, Judge. The clerk called 911 and previously told the officers that the defendant was previously issued a criminal trespass warning from a previous case. And he was criminally trespassed on July 19th, 2021, and there was no expiration date on that trespass warning. Officers caught the defendant walking towards the Economy Hotel, and which he was also criminally trespassed from there on February 14th, 2023, with no expiration date on that criminal trespass warning, Judge. So just based on his history and the facts that he was previously criminally trespassed back again, we would ask that the bond remain as set.
So, if you're speaking, you're on mute.
I wish when I come out from the breakout room, I'm still on mute. I'm on mute. Yes, Your Honor. Mr. Gillum is 32 years old, Your Honor. He's been in Georgia for over 22 years now. He does have a high school degree from Roswell, Sentinel Roswell, Your Honor. Since then, he has pretty much just been doing on and off landscaping jobs and odd jobs here and there. That is how he supports himself. So he has very limited income, but he does have family here. He has a mother, a niece, a girlfriend as well. So we're just asking for, at this point, if it can't be a signature bond, because I love signature bonds, we would have it be set at $1,000 good bond.
I think that based on his history that I'm going to leave it where it's already been set, the $1,500 good bond. Stay away from the Exxon on Holcomb Ridge Road. Stay away from the Economy Hotel on Old Dogwood Road, and no drugs, alcohol, or weapons while out on bond. Good luck to you, sir.
Position 8, Gibson.
Good afternoon, Mr. Gibson. I'm Judge Eric Morrow. This is the state court expedited accusation calendar that we're conducting by video. Do you agree to have your case heard by video?
Yes, sir.
Thank you. Mr. Gibson, you've been charged in case 23 CR 000978J with driving while your license was suspended or revoked, no insurance, theft by receiving stolen property, and having an expired or no license plate or decal. Is there a history, Ms. Roberts?
showing 36 cycles, multi-state offender, 23 of those arrested out of Florida, 1 FTA from January of 2022, a traffic violation conviction, 2021 out of Florida, a possession of cocaine, and escape conviction, 2008 out of Florida, driving while license suspended or revoked, 2007 out of Florida, a robbery conviction, 1992, Georgia, a bad checks conviction, 1991 out of Georgia, and given false name, 1991 out of Georgia, and nothing further.
Ms. Reiser.
Yes, Judge. The defendant's bond is currently set at, I'm showing 5,000 surety on each count, making it a $20,000 surety. Judge, normally I would agree with the bonds as set, but given these offenses, I would ask for 1,500 on each to lower that bond amount. I still would ask that they are surety bonds. On February 19th, Officer Hill of College Park conducted a traffic stop on the defendant's vehicle. His license plate came up on a flock camera as returned as stolen. When they did the traffic stop, the actual license plate was found to be stolen out of Gainesville, Florida, had a report number. The defendant informed the officers that his car was not registered, so he should have known that that license plate was not accurate and or stolen. The car was not registered. He had a suspended license and no insurance on the vehicle, Judge. So he is, given his history, it's lengthy out of Florida. He is a multi-state offender. All of his history in Georgia, I'm showing is from the 90s. So I think that the 1,500 on each count surety would be reasonable in this sense, Judge.
Ms. Hogue.
Yes, Your Honor. Mr. Gibson is 58 years old, Your Honor, and he has lived between Georgia and Florida for all of his life. He was born in Tennessee. He came here after college. He graduated Tennessee from Brandon High School and then went immediately into the Marines, where he served for 3 years in the Marines and was honorably discharged in 1985. And then at that point, he came here to Georgia, where he did some college, as well as got into computer networks and engineering, which he did for another 14, 15 years before he switched to construction, Your Honor. He was living in Florida, and then recently in this last year, he decided to make the move to Georgia. That's why he is here. He is here permanently. He's here to stay. And he has a job here with Lewis Contractors building the new treatment facility. So it's very important because he's working on that job right now. So it is a very important job for him to be able to get out and keep, as he's just come back here after being gone for a number of years. He's been married for 20 years, Your Honor. He has 3 grown children and a wife who's also moving up here at the same time. So it is a transitional period for them. I understand he has a history, Your Honor, but other than a 2021 traffic, and I'm not sure what the failure to appear was in 2022, we're going all the way back to 2008, 2007, and in the 1990s. So it's definitely old history. And given his stability and his desire to be here permanently, Your Honor, as well as the fact that he had stated that he didn't drive the car up here from Florida. It was his grandson. And so he probably should have, understood that probably wasn't the tag or who knows what, but these are, in fact, he was not, in fact, even violating anything traffic wise. They were running one of those things that, they can zap your tag and all that. So he wasn't even violating speeding or anything. They pulled him over solely because they ran that tag. So I believe, given all those factors, and he's just starting up here now, trying to get settled in here, that 500 on each charge is more than sufficient to assure his presence in court, because he intends to be in court and he intends to take care of these issues. And I believe that is just more than ample for each charge.
$500 on each charge, $2,000 total good bond, no driving without a valid license, and no drugs, alcohol, or weapons while out on bond. Good luck to you, Mr. Gibson.
Thanks, sir.
You're
Sure.
welcome.
Judge Mar, I'm not sure if that, you said it correctly. Is it 2,000 total, 2,000 good bond?
Yes, 500 on each charge. I think there are 4 charges, so if my math is right, that's 2,000.
Thank you. Position number 6, Frampton.
How are you doing?
I'm doing well, Mr. Frampton. I hope you are well, doing as well as you can do. I'm Judge Eric Morrow. This is the state court expedited accusation calendar that we're conducting by video. Do you agree to have your case heard by video?
Yes, Your Honor.
Thank you. Mr. Frampton, you've been charged in case 23 CR 0000976H with driving under the influence of alcohol, a concentration of 0.08 grams or more. Is there a history?
I'm showing 5 cycles, multi-state offender, 2 out of Ohio, 2 out of Pennsylvania. The last arrest was in 2020 out of Ohio for receiving stolen property. There is no disposition for that case. It appears to be open. And then a 2018 conviction out of Ohio for breaking and entering, and nothing further.
Judge, the defendant's bond is currently set on the DUI per se as a $4,500 surety. I ask that remain in place. I'd like to add the conditions of no drugs, alcohol, or weapons while out on bond. Judge, Officer Wells in this case was dispatched to 555 Atlanta Street in reference to a vehicle accident that occurred in the parking lot. When the officer talked with the victim and an eyewitness, they informed the police officer that the defendant backed out of the parking space and caused an accident. When they made contact with the defendant, he smelled of alcohol, strong odor of alcohol. The defendant admitted to having 3 mixed drinks, 2 beers. He also told the officers, and I quote, "I am intoxicated. You already know that. I already practiced the walk and turn evaluation before I went out tonight." The defendant did field sobriety evaluations. He was arrested and read the implied consent, consented to a breath test, and the results indicated his BAC was a 0.145, Your Honor. So given that and his multi-state status, I ask that the bond remain as set at $4,500 surety.
Yes, Your Honor. Mr. Frampton is a young man, 24 years old, Your Honor. He was living in Pennsylvania. I've asked him about if he has any they were questioning whether that 2020 or whatever out of Ohio, that has been resolved. So he has no open cases, Your Honor. He moved here from Pennsylvania to start a new life. Okay, to kind of get away from everything and start over. He admits it was very foolish. He didn't try to lie about what he had or anything, Your Honor. This was a parking lot situation. He is a young man with very limited income at this point in time. He is here living with his great uncle in Roswell, Georgia, so he has a stable address. He was working at at a previous restaurant just so he could get enough money to buy the shoes and things he needs to go to start at Steak and Shake. In Pennsylvania, Your Honor, he graduated from high school from a Keystone charter school with a 4.0 average. He was attending culinary arts school there when he ran out of money, so he couldn't finish it. He really does want to cook and be a chef. He came down here to start over, and that's where when he goes to Steak and Shake, he is going to be starting as a cook. He's trying to get enough money together to go back to school to get his culinary degrees, Your Honor. Given all those factors and the fact that, like I said, he was very open, he agreed to everything. And given his limited funds right now, we do believe that a $1,500 good bond is more than sufficient to ensure his presence in court. He intends to stay here. He intends to create a new life here.
Okay. It's going to be a $3,000 good bond, no drugs, alcohol, weapons while out on bond. Mr. Hogue, your client has his hand up.
I'm sorry, Judge, I wasn't able to hear you. I had a little bit too much noise.
Okay. Well, first of all, Mr. Frampton, you have a right to remain silent. Anything you say can be used against you. I'm happy to give you the opportunity to speak to Ms. Hogue at a later time. I don't want you to jeopardize any of your rights, sir. As far as the bond goes, it was a $3,000 good bond, no drugs, alcohol, weapons while out on bond.
That's what I wanted to speak upon. Is that a fact there, sir? May I speak?
Don't
The only reason I'm asking,
Ms. Hogue is representing you, Mr. Frampton. And again, people often think that what they say might be of help to them, and it's quite often not. So I would, know that Ms. Hogue would advise you to just talk to her later after court today, and she'll answer all of your questions, okay?
I have to say one thing, Miss Elizabeth, Miss Hope.
Yeah, I will speak with you after court today. I'm going to be at the jail tonight to speak to all my clients.
It's just, there's no way I'm gonna be able to afford that amount.
Yeah, Your Honor, the one thing I spoke with him, that's why 1,500 is about what they could afford. And he can lose his job if he does not get out, Your Honor. So that's why, like I said, given the fact that he was, very upfront and, understanding that what he did was wrong, I do believe 1,500 is more than sufficient. I do understand the court's concerns, but I understand his concerns as well.
And I don't ever want anyone to lose their jobs. And I understand that Mr. Frampton is starting over. It's a tough way to start over. But again, Mr. Frampton, I would prefer that you be working than sitting in jail. So I will take the recommendation of Ms. Hogue. It will be a $1,500 good bond.
Thank
Thank
you.
you, Your Honor.
All right, who do we have next? Good luck, sir.
Position 14, Lacy.
Good afternoon, Your Honor.
Good afternoon, Mr. Lacy. I'm Judge Eric Morrow. This is the state court expedited accusation calendar that we're conducting by video. Do you agree to have your case heard by video?
I do.
Thank you. Mr. Lacy, you've been charged in case 23 CR 000985F with simple battery family violence. Is there a history?
I'm trying to assess the first arrest.
Okay, thank you. Ms. McCutcheon?
Yes, Judge, the state concurs. This is the defendant's first arrest. He's charged with simple battery. The state would expect the evidence to show that on January the 24th of 2022, this is an arrest following an outstanding warrant. The defendant was involved in a dispute with the victim, a Miss Jenny, common spelling Jenny, I-E, ending, last name Polone, P-O-L-O-N-E. The victim stated that the defendant, who was her boyfriend, squeezed her side, then placed his left hand around her neck and choked her. However, she did not lose consciousness, nor did she exhibit signs consistent with strangulation. Our office has not had any success in contacting her. We did attempt today, Judge, but
I'm sorry, excuse me, I'm sorry, I didn't interrupt. We do have the victim here. She did say she wants to speak.
Oh, okay, Ms. Polone is here. Okay, that's good, Judge. As I was saying, we had ran the number that we found for her. The mailbox of the number that we located was full, and we had sent a text to her. So hopefully she did receive that text and she's on the Zoom. But going further, Judge, the state's recommendation would be a $2,500 good bond. The state was going to recommend no further contact with Ms. Polone, but since Ms. Polone is on the Zoom, she may be able to offer some other information in that regard. And the state's recommendation was going to be to stay away from the incident location, which was 710 Peachtree Street, apartment 324, Atlanta, Fulton County. And Judge, would you like to hear from Ms. Polone?
She's actually here in the courtroom.
Oh, she's in the court. Okay.
So if you can go ahead and bring her up. Is this your case, Ms. Helen?
Yes, Your Honor.
Would you like for me to hear from Ms. Polone first, or would you like to?
I'd like for you to hear from Ms. Polone first.
Okay.
You can just stand right here by the green chair. Just stand there. Okay.
Good afternoon, Ms. Polone. I'm Judge Eric Morrow. Can you raise your right hand for me?
Yes, I can.
Do you swear affirm the testimony you're about to give before this court will be the truth, the whole truth, and nothing but the truth?
Yes, Your Honor.
Okay, you can put your hand down, Ms. Polone. What would you like to tell the court?
I would like to tell you that during the incident, we both had an argument. We are engaged. We have a 6-month-old beautiful daughter. From that situation, there was no arrest. There were no charges at all on either side from any situation. We have gone through therapy on our own and together. This situation happened last year. We had no idea there was any warrant, any situation at all. We are engaged. We have a beautiful 6-month-old daughter. We're doing everything and as together, bringing up our family.
So you're not afraid of him?
Of course not. No.
Okay. And this is not, has this happened before?
No, it has not. No, it has.
Okay. Would you like to tell the court anything further?
No, I think that's all.
Okay, thank you, Ms. Pallone. I appreciate it.
Thank you.
Ms. Helen?
Yes, Judge, I am very thankful for Ms. Pallone because again, when I spoke to Mr. Lacy, he stated the very same things, that they are both in a committed relationship. They are both planning to become married. They do have a 6-month-old child together. And then when I spoke to him, this is his first arrest. So this is not a long-time career standing offender. He is not a violent offender and has no history of doing so. And as as she already testified to, this isn't something has happened before. He's 34 years old. He is self-employed. Although we are covering the bond hearing for this appearance, Judge, he does not qualify for the services of the Public Defender's Office. How well he's doing as a self-employed entrepreneur. He has a bachelor's degree in business management and psychology. He is not from Georgia, he's from Virginia, but he has been in Georgia for the last 6 years, again, with his now fiance and child and is a resident. He got that degree from Radford University in Virginia. He does have another daughter, I believe his 8-year-old daughter. Again, Judge, we are asking for that signature bond, not in $2,500. Mr. Lacy cannot afford that. He can afford a $1,500 signature bond, Judge. And I understand it's a signature bond, but just for the value.
Okay. Well, it's a signature bond, so it's going to be a $3,000 signature bond through pretrial per the judge, 1-day anger awareness, no further violent contact with Ms. Pallone, and no drugs, alcohol, weapons while out on bond. So I'm going to let you out, Mr. Lacy, on a signature bond, but you're going to have to make sure to show up for your next court appearance. Otherwise, they're going to put a warrant out for you, okay?
All right, not a problem. Thank you.
All right, good luck to you, sir.
Thank you.
Position number 5, Fowler.
How you doing, Judge?
I'm doing well, Mr. Fowler. Let's see. I know I have a Prince Fowler and a John Fowler. This is Prince Fowler? Or
Sir, it's pronounced Prentice.
Prentice. All right. I'm sorry, Mr. Prentice. Mr. Fowler, I'm Judge Eric Morrow. This is the state court expedited accusation calendar that we are conducting by video. Do you agree to have your case heard by video?
Yes, sir.
Thank you. Mr. Fowler, you've been charged in case 23 CR 000980F with battery family violence. Is there a history, Ms. Roberts?
I'm showing 4 cycles, 1 conviction for simple battery in 2002, and 1 probation violation in 2006, and nothing further.
Judge, yes, Judge. The state is recommending a $5,000 surety bond and with the added conditions of no contact with Gabrion Hammond. First name is Gabriyon, last name Haymond. Your Honor, officers responded to a hotel at 3420 Normanberry Drive in Hapeville. They met with Ms. Haymond, who informed police that the defendant took her phone, would not give it back. A physical altercation ensued where the defendant struck the victim in the head, causing a visible knot on her head. The victim also disclosed to the officers that the defendant, when they were driving in the car earlier that night, the defendant also grabbed her arm, put his hand around her neck, and pushed her up against the driver's side window. The officer, again, in addition to observing the knot on her head, observed visible scratches on her neck. Based on the family violence nature, is they reside together and share a child together, Your Honor. He does have a previous simple battery. I know it is back from 2002, but it does pose a little bit of concern for the state. And we believe that a $5,000 surety, given these facts and the visible bodily injuries to Ms. Haymond, that this surety bond is reasonable, Judge.
Thank you. Ms. Hogue.
Yes, Your Honor. Mr. Fowler is 38 years old and was born here in Georgia and has lived here for up to 25 years until he moved to California, where he actually currently lives with Ms. Haymond in California. They were here visiting, Your Honor. They're flying out as soon as they can. They are currently engaged and they've been in a relationship for over 10 years right now. One thing about the facts that was not noted was that in each case, they were having a verbal argument upon which it was Miss Heyman who actually initiated the physical actions first, and she admitted it, and he said so too. So, and she was originally charged, but now she's been nodded. But interesting enough, she admitted to the police that they were having a verbal argument, and she's the one that struck him. Okay, in both instances, one while he was driving, while they were in the car driving. So, but they've decided to not prosecute her. They both live in California, Your Honor, and they both live together there. Right now, he's the one that has the family here, not her. Like I said, his family is here. He moved to California, but his family is here. He grew up here. He graduated from East Coweta High School. He has been in he's a mechanic tech for aerospace, working for Coors Brakes. He's been doing that for 6 years. He's had other jobs along that way, so he's been gainfully employed this entire time. He has 6 children, 2 of whom live here. Your Honor, I believe given his significant ties and everything else here, well, I know you don't like to do signature bonds on this situation. I think $2,000 good bond is more than enough to assure he is coming back here, as he comes back here frequently to see his family. They were here for a birthday and other occasions. As far as, contact goes, they are living together, they're engaged, and they've been together for 10 years living in California. So I'm not sure even if you could enforce a no contact in California. But we would say there should be no further violent contact.
You put me between a rock and a hard place, Ms. Hogue, because you tell me on one hand that they want contact, and then on the other hand, you tell me that I need to protect himself from her. It sounds like that neither one of them need to be around each other. And whether or not it can be enforced in California, it's an order that's issued here, and that if they're having contact and he comes back here, then that's going to be a problem here.
Judge, respectfully, if I can just speak, I know one lawyer
Please
will
do.
issue rule, but Your Honor, just to be candid with the court and opposing counsel, Ms. Reiser and I did communicate about this case this morning. And we were concerned because both parties were in fact arrested, and we determined that we needed to, although the female defendant was determined to be the initiator, we both agreed that the defendant that was accused was actually the primary aggressor based on the conduct and the injuries, the visible injuries that were sustained. There's a difference, Your Honor, legally between the state's evidence as to who initiated and who is the primary aggressor. And of course, we will have to prove that beyond a reasonable doubt should the case move forward. But it was the state's determination that the defendant before the court now was the primary aggressor. And the state still stands by its no contact, Judge, because these parties apparently on that particular date, especially here in the state of Georgia in Fulton County, were both involved in a confrontation that turned out to be physical and ended up in an arrest.
And I agree with you, Ms. McCutcheon, with regard to the contact. I don't feel comfortable, given what I've been told, to allow them to have contact at this point in time. So it's going to be a $3,000 good bond, no further contact with Ms. Hammond, third-party transfer for child visitation, and no drugs, alcohol, or weapons while out on bond. All right, good luck to you, Mr. Fowler.
Oh, thank you.
Position 21, Walker.
Yes, good afternoon, Mr. Walker. I'm Judge Eric Morrow. This is the state court expedited accusation calendar that we're conducting by video. Do you agree to have your case heard by video?
Yes, ma'am.
Thank you, Mr. Walker. You've been charged in case 23 CR 000992D with loitering and prowling. Is there a history, Ms. Roberts?
Yes, 22 cycles, 1 FTA from 2019, a total of 4 probation violations. I'm showing a 2022 arrest for theft by receiving stolen property, possession of drug-related objects, sale, distribution, or possession of dangerous drugs, and possession of VGCSA. That case appears to be open. I have to double check what county it was out of. I'm also showing a probation for possession of meth. The disposition was February 11, 2021. It was 4 years, 10 months probation. And then a second probation for possession of meth, same disposition date. It was 2 years probation. 2015 forgery conviction. 2017 no license on person conviction. Simple battery family violence conviction. 2012, and then a theft by shoplifting conviction in 2011. And nothing further.
Thank you. Ms. McCutcheon?
Yes, Your Honor. I don't believe pretrial mentioned the 2012 possession of a firearm by convicted felon. I don't know. That's case number 12 SC 108320 that the state shows on the defendant's criminal history, in addition to the drug and forgery and theft by shoplifting convictions. Pretrial did mention the theft by receiving and the possession of felony drugs, not knowing which jurisdiction. That's from a July 10th, 2022. The state's records show that's still pending. That was a Brookhaven Police Department, which would make that a DeKalb County case. And as far as the probation violations, the state shows that there are 5. I know pretrial said 4. We show that there was 1 in 2002 in 2014, 1 in October of 2014, 1 in September of 2014, 1 in July of 2013, 1 in March of 2013, and 1 in September of 2028, which the state would submit to the court based on these 5 prior probation violations does not make this defendant a good candidate for pretrial, makes this defendant a risk of reoffending and not appearing for court. So the state's recommendation, Judge, based on these facts and these charges, and the defendant is in fact in this case charged with loitering and prowling on February the 18th of 2023 at the location of 761 Morosco, Morosgo Drive in Atlanta, Fulton County. The victim in this case is a Mr. last name Lowe, Lowe, first name Trevione. I believe that would be Trevion, who stated to the police on the incident date that the victim, someone identified later as this defendant, had used a sharp object, stuck it in the keyhole of his residence, and tried to open the front door to the victim's apartment. That was apartment 103. At that 761 Morosco Drive, Atlanta address. Our office was able to make contact with the victim, Judge, and I'll state my place. The victim stated he would not be on Zoom. However, he stated he did not know the defendant, does not know the defendant, had never seen him before this incident. He stated that the defendant tried to enter his home. He said he would like to have a no contact and a stay away from his home. And again, that's the 761 Morosco Drive, apartment 103 location. Judge, the defendant did not make entry, thankfully, but the state does not know if in fact he had made entry, whether his intent would have been to commit a theft or to commit a felony inside that location, or merely just a criminal trespass. But we don't have any evidence as to what would have occurred. But we submit these are aggravated facts that he took that substantial step to try to get into this victim's apartment. And so we would ask the court that based on the criminal history, that the defendant be ordered to have a Judge, let's see, following my notes, I'm talking so quickly, excuse me, Your Honor, a $5,000 good bond, that he have no further contact whatsoever with Trevion Lowe, name as I spelled it previously, and that he stay away from that incident location. And of course, no drugs, alcohol, or weapons while out on bond.
Ms. Helen?
Yes, Judge, we're having a bond hearing today for Mr. Walker. He is self-employed. He is a mechanic. He is from Georgia. He does have a 13-year-old daughter, Judge. On this event, I talked to Mr. Walker. He stated he was upstairs visiting a family member, a cousin specifically, at the top level. As he's coming down, leaving this residence, the alleged accuser busts out to the apartment, says, "You tried to enter my apartment." Mr. Walker did not try to enter or make any metal piece to enter in the door. He's walking past it. When I spoke to Mr. Walker, he understands the seriousness of it, Judge, but for a $5,000 good bond, I think is extremely high. We're asking for a bond of no more than, we're asking for a signature bond. We are asking for a signature bond of no more than $1,000. If you feel that he's ineligible for that signature bond, we're asking for a surety of no more than $500, Judge. Again, when I spoke to Mr. Walker, he was walking down from visiting a family member past this apartment, and that resident immediately came out and accused him that he made no contact with the door or anything around it.
Okay, it's going to be $1,000 good bond, no further contact with Mr. Lowe, stay away from the apartment 103 at the 761 Morosco Drive address, and no drugs, alcohol, or weapons while out on bond. Good luck to you, Mr. Walker.
Position 19, Simpson.
Good afternoon, Mr. Simpson. I'm Judge Eric Morrow. This is the State Court Expedited Accusation Calendar that we're conducting by video. Do you agree to have your case heard by video?
Yes.
Thank you. You've been charged in case 23 CR 000990G with theft by shoplifting, battery, possession and use of drug-related objects, and simple battery against a police officer. Is there a history?
10 cycles, 3 out of Maryland, 7 out of Georgia. I'm showing a open case, 23 CR 000018J. That's for criminal trespass and possession of use of drug-related objects. And then I'm showing an open probation for criminal trespass, 22 CR 004200J. That is from July 7, 2022, 12 months probation. And then I'm showing a 2017 conviction out of Maryland for violating a protective order, and 1 FTA from 2017 as well out of it. And nothing further.
Thank you. Ms. McCutcheon?
Yes, Your Honor. On the incident date of February the 20th of 2023, the officers responded to a location of a Texaco gas station at 635 Lindbergh Drive, Atlanta, Fulton County. This is in regard to a shoplifting call. Upon arrival, the officer met with the victim, whose name is first name capital M, D as in David, last name K as in kangaroo, H as in Hector, A as in Apple, N as in Nancy, who stated that a black male had stolen a 4-pack of wine and broke another bottle inside of the store. He also stated that the male had punched him on the left side of his face, making him fall and sustaining injury to his legs and arms. The officer observed visible bruising on the face, legs, and arms of the victim due to the alleged punch. The victim was able to provide a photograph of the subject. The victim said that the subject, later identified as this defendant, Rayfield Simpson, frequently shoplifts at that location, but by the time the police arrived, that he has fled the scene, so he had never been apprehended. The officers canvassed the area, found that the male who matched the description located nearby at 741 Morosco Drive. He was on the sidewalk at that location. The officer explained to him the reason that he was being detained, relocated him back to the Texaco. And when he arrived at the Texaco, the victim positively identified him as the person who had assaulted him. The state is recommending that the defendant be given a bond in the amount of $2,500 good bond on the theft by shoplifting, a $3,000 good bond on the battery, visible injury. And I failed to state to the court that once the defendant was apprehended, he did in fact have drug paraphernalia on him. So the state's recommending a $1,500 good bond on the drug-related object. And when he was, once he was told that he was being placed under arrest, at the precinct, the officers tried to explain again the charges and the reasons that the defendant was being arrested. He began spitting towards the officer, calling him the N-word, saying, "I will spit on you." Once he was calm, the officer was able to put a spit mask over his face to prevent him from continuing to spit on the officer. And he was finally subdued and taken into custody and booked accordingly. So on the simple battery against a law enforcement officer, the state is recommending also a $3,000 bond. So a total of $2,500 plus $3,000 plus $1,500 plus $3,000 for a total $10,000 good bond, Judge, based on the nature of the factual basis of the case and the defendant's prior history. That he stay away from the victim, MD Khan, and that he have no further contact at all with MD Khan, and that he stay away from that Texaco located at 635 Lindbergh Avenue in Atlanta, Fulton County.
Thank you. Ms. Helen?
Yes, Judge. Mr. Simpson is 30 years old. We are asking for a signature bond for Mr. Simpson. I did hear his history, but I didn't hear any violent charges or any repetitive charges as we're seeing here today. We are asking for that signature bond. When I went and spoke to Mr. Simpson, he stated he had no physical contact with any gas station attendant at all. He also has some high school education as well. He's currently working as a cleaning attendant for the last 2 years at the Peachtree Center, Judge. He is from Maryland, but he's been in the Georgia area for the last 7 years. He is a proud father of 2 girls, 9 years old and 7 years old. And so just based off the history, Judge, I do hear the allegations that are mentioned here, but Judge, we are asking for that signature bond, not in 10,000. He cannot afford. If it's a signature bond, we accept that. But if it's a good bond of 10,000, Mr. Simpson cannot afford that. So we are asking for the bond for the theft by shoplifting to be no more than $500 against signature. The battery, no more than $1,000 signature. The possession of drug-related objects, no more than $250 signature. And then the simple battery allegations of the spit, Judge, we're asking for a $1,000 signature bond. And so, Judge, again, when I spoke to Mr. Simpson, he would not be able to afford a $10,000 good bond. That's effectively a no bond. He would lose his employment and maybe even his place of residence, Judge. So we are asking for that signature bond. If you feel that he's ineligible for the signature bond, we are asking for the same amount in a good bond, Judge.
Okay, for the theft by shoplifting, a $500 good bond. For the battery, a $1,000 good bond. For the possession or use of drug-related objects, a $500 good bond. And for the simple battery against a police officer, a $1,000 good bond, making for a total of a $3,000 good bond. Excuse me. Stay away from the Texaco on Lindbergh Avenue. No further contact with the alleged victim, Mr. Khan, and no drugs, alcohol, or weapons while out on bond. Good luck, Mr. Simpson.
Position 15, McClendon.
Good afternoon, Mr. McClendon. I'm Judge Eric Morrow. This is the State Court Expedited Accusation Calendar that we're conducting by video. Do you agree to have your case heard by video?
Yes.
Thank you. Mr. McClendon, you've been charged in case 23 CR 000986C with criminal trespass, willful obstruction of a law enforcement officer, and terrorist threats and acts. Is there a history, Ms. Roberts?
13 cycles. Open criminal trespass case 23 CR 000920C. I'm showing an active probation for aggravated assault strangulation 21 SC 178868. Disposition February 15, 2022 was a 10-year sentence. A possession of cocaine conviction 2017. Theft of services conviction 2006. Burglary conviction 2005. Theft by shoplifting conviction 2005. Criminal trespass conviction 2004. And then a total of 2 probation violations. And nothing further.
Thank you. Ms. McCutcheon.
Yes, Judge, the state concurs with pretrial's recitation of the criminal history. And we would just like to make the court aware that the defendant was arrested on February the 15th of 2023 on that 23 CR 000920C case, where he was charged with criminal trespass of yet another hotel. And that hotel location was the JW Marriott Hotel at 3300 Lenox Road. In the instant case, the criminal trespass was at a hotel located at 181 Peachtree Street, the Ritz-Carlton, where officers responded to that location in regards to a criminal trespass, spoke with the manager, Mr. Stanley Smith, who stated that a white male came into the lobby, sat down. Once he noticed the male, he asked if he was a guest. He stated he was not. The hotel employee then told the male, identified later as Mr. Van McClendon, to leave. He left the lobby, the defendant, but remained on the property in the valet area. Mr. Smith again told him to leave, but he refused and stated to the employee to go ahead and call the police. The officer arrived at the location, observed Mr. Smith ask Mr. McClendon several times in the officer's presence to leave the hotel. However, he refused to leave. He shouted to the officer, "Take me to jail." Even when the officer then stepped in and asked the defendant to leave, he refused, saying again, "Take me to jail." At that time, he was placed into custody and transported to Grady Hospital, where the jail refused him and stated that he needed medical clearance before being booked into the jail. He threatened the officer by stating that he was upset and that he was going to find out who, I guess, find him out, and that he would make the officer disappear. The officer asked Mr. McClendon if that was a threat, and Mr. McClendon responded to the officer, according to the officer's warrant, "No, it's a promise." And that is the factual basis for this case, Judge. And once the defendant was cleared from Grady, he was then transported to Fulton Hospital. Again, while he was in the patrol vehicle being transported to the jail, he said to the officer that he was going to hurt him. The state would, based on the defendant's criminal history, Judge, the fact that he's actually under sentence in the aggravated assault, has a criminal trespass where he's on bond. And this instant case happened, I believe, Judge, 5 days after he was released on bond in the case where he was charged with criminal trespass of the Marriott. The state's recommending a $2,500 good bond on the criminal trespass, a $1,000 good bond on the obstruction, and a $2,500 good bond on the terroristic threats against the officer, for a total of $6,000 good bond, Judge.
What was the bond, Ms. McCutcheon, that he was given on the February 15th?
Yes, Judge. I thought I had that information. I can look it up. He was given a $3,000 SOB for criminal trespass in the 23 CR 0009203 C. It was a $3,000 SOB bond.
Thank you. Ms. Helen.
Yes, Judge. Mr. McClendon is 58 years old. Just to address his history, that aggravated assault, he did 235 days of incarceration for that. And then he was released to a program, Michael and Michael, which I believe is a behavioral counseling program. And when I spoke to Mr. McClendon, he was successful in that program. Coming to this incident, Judge, we are asking for a signature bond for Mr. McClendon. He is 58 years old. I do hear the history, but he would not be able to afford the current bond at the state's request. And when I spoke to him, he stated that the officer was being quite rude to him and he only wanted to protect himself, that he didn't offer any danger to the officer. He merely wanted him to leave him alone and give him a little space. And so, Judge, I am asking for that signature bond. Mr. McClendon is homeless. He has been residentially challenged for the last several years here in Georgia. He's not from Georgia, he's from Virginia, but he's been homeless in Georgia for the last several years. He does have a 12th grade education. I have spoken to him about the men's shelter here in Atlanta that offer beds, shelter, food, and housing, Judge. He does have children, but they are all quite adult, but he does have children, Judge. And again, he is 58 years old. I do hear the history, but we are asking for that signature bond. If you feel that he is ineligible for a signature bond, we are asking for a surety bond in the amount, the first amount, the criminal trespass, $500 signature. The obstruction, a $500 signature, and the terroristic threats, a $500 signature, for a total of $1,500 bond. Again, if the judge feels that, you know, he's ineligible for the signature, we are asking for the surety in that amount.
I don't think we can't just keep giving him signature bonds, Ms. Helen. I think he needs some help in some way. So I'm going to order a social worker visit.
Okay.
So if I see him back on my SAP calendar, whoever's representing him at that point in time, would you please have them report regarding the social worker visit? Right now, it's going to be a $500 good bond on each charge, which makes it for a total of a $1,500 good bond. Stay away from the Ritz on Peachtree, and I guess no further contact with Mr. Smith, and no drugs, alcohol, or weapons while out on bond. And once you have the social worker visit report to me, I'm happy to reconsider if we can get him some services. Okay. Yes,
Your Honor. I'll go ahead and submit that request for a social worker visit now, and just make sure they can get ahead of that.
Okay, I appreciate it.
And just to make Yes, Judge, just to make the court aware, I did look at the sentencing on the aggravated assault strangulation case, and services were a condition. I think counsel for the defendant mentioned the actual program. That was a condition of that sentence about a year ago in February of 2022, when the judge signed the order regarding the aggravated assault strangulation case. So I thank you, Judge, for the court's ruling.
So, Ms. Helen, given that, it sounds like he might be off of not attending or whatever. So if we can maybe get him back straight, it might be helpful. All right. Good luck to you, Mr. McClendon. If you don't get out, I'll see you back in a couple of weeks.
I don't understand what's gonna happen.
Ms. Helen, go ahead, Ms.
Mr.
Helen.
McClendon, I will give you a call today and let you know what happened, okay?
But what time?
I can call you now. They want to do a breakout session now. However, I can speak to Mr. McClendon. Can I just call them at courtroom 2?
Would you mind just talking with him after court, Ms. Helen?
Understood, Judge.
Okay. She'll talk with you after court today, Mr. McClendon.
Thank you very much, Judge. May peace be upon you forever. I love you all.
Position 13, Jude.
Good afternoon, Mr. Jude. I'm Judge Eric Morrow. This is the state court expedited accusation calendar that we're conducting by video. Do you agree to have your case heard by video?
Yes.
Thank you. Mr. Jude, you've been charged in case 23 CR 000984J with aggressive driving. Is there a history, Ms. Roberts?
I do. Showing one cycle out of Virginia from 2022 for a DWI. And that was a guilty conviction from September of 2022.
Okay. Thank you. Ms. McCutcheon?
Yes, Judge, this is a case where the state would submit to the court a road rage incident. According to the victim, the offense is alleged to have occurred on February the 17th of 2023 at the location of Martin Road and North Pond Circle in Fulton County. Officer responded to that location, was flagged down in that area in reference to the incident by a Miss Mary Ann, one word, Mary Ann, last name Flanagan, Flanagan, who stated that the defendant chased her around the neighborhood in his Honda CRV. She explained that she went to confront the defendant who at his place of residence about an incident that had occurred at her home located at 9200 Nesbitt Drives Lake. She suspected that the defendant had driven his vehicle through her yard as she had discovered tire marks in the yard. And she expected this was done by the defendant due to his erratic behavior that she had reported previously in another case. She knocked on the door at the defendant's home, attempted to make contact. When she did not get an answer, she said she began collecting some items that were laying around outside on the ground. The defendant then opened the garage door, backed out of his driveway, and she was nearly struck by the defendant's vehicle as he was leaving the driveway. Although there are no witnesses or video to corroborate this claim, she did report this to the police, and she stated that the defendant then followed behind her vehicle, honking his horn constantly as she attempted to speed up to evade him. He sped up with her and continued in close pursuit of her vehicle. There's camera footage of this event was later provided by another witness who witnessed the event and provided a statement to the police. Based on the facts before the officer then charged this defendant with the aggressive driving accordingly. The state is recommending a $2,500 good bond, that the defendant have no further contact with Mary Ann Flanagan. Judge, even though this is the defendant, this is his first arrest for this type of offense. This is a serious public safety issue, occurred in public roads. The allegation was that he was driving very aggressively at high rates of speed and placed the victim in risk of harm and in fear. So that's the state's recommendation for bond.
So Ms. Flanagan and Mr. Jude, they in some way know each other.
It appears so, Judge, because according to the report, she suspected for some reason or other that he was the one that had driven onto her yard and apparently had made a complaint about this previously.
And she admitted to trying to take things out of his yard?
Well, she said there were things that were laying on the ground, and she started retrieving these things that were on the ground.
Okay.
And then the defendant came out of the vehicle and apparently she got into her vehicle and the defendant, as he was backing out, almost hit her, according to her, and then started driving aggressively and following
Okay.
her, according to the victim.
Thank you, Ms. McCutcheon. Ms. Helen?
Yes, Judge. Mr. Jude is 29 years old. Again, other than this incident or this allegation, he only has the DWI. So he doesn't have a violent history. Just to give some clarification who Ms. Flanagan is, she is the lease or the landlord who's mentioned on his lease contract. And Mr. Jude is the tenant or subtenant, and he has a proof of that lease. And he's told me that he is that current tenant. So when I spoke to Mr. Jude, the basis for the aggressive driving, this landlord showed up at a residence that he is legally paying for, that he is legally renting. He's not behind on any type of rent or anything. She shows up, she begins taking things from the front yard. She's already trespassing because he's already asked her not to be there. When I spoke to Mr. Jude, he asked her when he saw her in the front yard, please leave, please leave. She did not. Please leave. So Mr. Jude wanted to leave that situation because she believes she can show up to the front door to do those things. He tried to leave. I don't know how he could try to leave and run her over when she's trying to grab things from the front yard. He leaves. Miss Flanagan then tries to contact the police, saying that he aggressively followed her, not on a highway, not out of state, but through the neighborhood. And I talked to Mr. Jude, the neighborhood speed limit is about 45. And he followed her just around the neighborhood as far as his home, the block, to ask her to leave him alone. Okay, she's in his vehicle, or she's in her vehicle, he's in his vehicle. He's like, please leave me. I'm trying to leave and you're following me. Can you please leave me alone? So Judge, just based on the history, he's not a long-standing violent offender. Based on the allegations, nowhere in the warrant, and I think you may have read the warrant, Judge, did it say that they were going 60 or 70 miles an hour. It just said that there was video footage of him following her car. So we are asking for a signature bond, no more of $1,500, Judge. When I spoke to Mr. Jude again, he stated he followed her to just get her away from the property and away from him, not to aggressively harm her or offer her anything aggressively, Judge. He does have an education, a bachelor's degree in political science, as well as a minor in communications from St. John's University. And so, Judge, he is from Minnesota, but he's been in Georgia for the last several months, Judge, living at that residence, establishing his lifestyle, Judge. So we are asking for that signature bond. She is the landlord, but we're asking for no violent contact. And I guess no contact unless it involves the lease. So that's what we're asking for, Judge.
Well, they're gonna have to get a third party to mediate between them, because I'm not gonna allow contact, regardless of whether they're, what their relationship is like. Ms. McCutcheon, did you have something else?
Yes, Your Honor. I wanted to add that according to the warrant, the officers admitted that initially they did not have probable cause. It was only after they observed the video that was provided by a third independent witness. Once the officers observed the video, then they determined that they did in fact have probable cause to charge the defendant with the aggressive driving, because they were able to see the driving that was occurring with the defendant pursuing the victim's vehicle.
And I do hear that part, pursuing her vehicle, but again, that there was no testimony to specifically the speed or a certain amount of speed behind that vehicle.
It's going to be a $2,000 signature bond through the jail. No further contact with Ms. Flanagan. Ms. McCutcheon, does Ms. Flanagan live at the Nesbitt Drive, 9200 Nesbitt
Let me
Drive?
just check. Let me check, Judge, to verify that, what address we have for her. And I'm sorry, Judge, it's still twirling. Okay, let's see. And Judge, I do not show an address. What we have, of course, at this point, what we have is the warrant, and the warrant does not have an address for for her.
I apologize, Judge. Just in the warrant, she stated, or at least the officer believes that her address was the 9200 Nesbitt Lakes Drive.
Right. I don't know if that's an apartment complex. You're right, Judge. I'm looking at the warrant. At her home located at 9200 Nesbitt Lakes Drive. You're correct, counsel.
Okay, so stay away from that address. and no drugs, alcohol, or weapons while out on bond.
And
All
I
right, good
just,
luck to you, Mr. Jordan.
I'm sorry, Judge, don't mean to interrupt you,
No,
but
you're fine.
his daughter, or excuse me, not his, Miss Flanagan's daughter is a go-between between Mr. Jude and any questions he has about his lease. So I guess I just want clarification from Mr. Jude. That includes no text messages to Miss Flanagan, no social media, no emails, nothing.
Okay, there will have to be third-party contact between Ms. Flanagan and Mr. Jude. So however that's accomplished.
Understood, Judge.
All right, good luck to you.
Yes, what was that amount again, Your Honor? I'm sorry.
$2,000 signature bond through the jail.
Thank you. Thank you, Judge.
Position 20, Mr. Tovar, Spanish interpreter case.
Okay.
Second bench.
Madam Interpreter, if you can raise your right hand for me, do you swear firm that you will translate from Spanish to English and English to Spanish to the best of your ability?
I do, Your Honor.
Thank you, I appreciate it. Mr. Tovar Garcia, good afternoon. I'm Judge Eric Morrow.
Buenas tardes, señor Tovar García. Yo soy el juez Eric Morrow.
We are conducting this hearing by video. Do you agree to have your case heard by video?
Estamos conduciendo a través de esta teleaudiencia. ¿Usted acepta continuar que tratando su caso de este modo?
Sir.
Yes.
You have been charged with simple battery family violence.
Usted tiene un cargo de golpes y lesiones, violencia familiar.
Ms. Roberts, is there a history?
¿Hay un antecedente, señora Roberts?
9 cycles.
9 ciclos.
A DUI arrest from October of 2022.
Hay un arresto por manejar bajo los efectos del alcohol en el 2022.
The case appears to be open.
Parece que el caso todavía sigue abierto.
2004 DUI conviction.
También hay una sentencia, un dictamen en el 2004 por manejar bajo los efectos del alcohol.
2005, 2 counts of affray conviction.
2 counts of what?
Affray. Fighting.
También por conducta inapropiada en el 2005.
2015 conviction for expired license.
Y también por manejar con una licencia vencida. ¿In what year, madam? I sorry.
2015.
En el 2015.
2 arrests out of Illinois and nothing further.
Y hay 2 arrestos desde el estado de Illinois. Nada más.
Ms. McCutcheon.
Yes, Your Honor, the state agrees with pretrial's recitation of the history with the addition that the state shows that the Illinois arrests, no dispositions, were for the offenses of battery. And those were in 2019, and the year 2000 for one, and in the year of 1998 for the other. Judge, this case.
1 moment, please. 2001, in what year, madam?
No, I'm sorry. One of the battery arrests was in 2000.
Okay. And the other?
And the other was in 1998, both in Illinois for battery.
Y los cargos otorgados en el estado de Illinois, no hubo un dictamen, pero estaban relacionados con los golpes y lesiones ocurridos en el 2000 y en 1998.
Judge, the state was unable to get in contact today with the victim, Ms. Rocio, R-O-C-I-O, last name Morales, M-O-R-A-L-E-S.
Su señoría, la fiscalía no pudo contactar a la víctima, Rocío Morales.
The state would expect the evidence to show, Judge, that on February the 18th of this year,
La fiscalía espera demostrar, si este caso va a juicio, que el 18 de febrero de este año,
at the location of 1823 Hemingway Lane in Fulton County,
que en la dirección de 1823 en Hemingway Lane del condado de Fulton,
2 officers responded to that location in reference to a domestic call.
2 oficiales de policía respondieron a una llamada por violencia doméstica.
Met with the victim, Ms. Morales, who spoke to them via a translator from the language line via telephone.
Y entonces encontraron a la señora Morales, con quien se comunicó con ellos a través de un intérprete de el language line.
Ms. Morales stated that she and her husband, identified as the defendant, Arturo Tovar Garcia,
Y la señora Morales indicó que al acusado, su esposo, Arturo Tovar García,
were arguing that he then placed his hand around and underneath her neck and pinned her against the wall.
Y también declaró que estaban discutiendo y que él colocó su mano alrededor de su cuello y la apretó sosteniéndola contra la pared.
As he held her against the wall, he raised his fist to strike her.
Y al tenerla sostenida contra la pared, él levantó su puño para golpearla.
And as he was about to strike her, her children, 3 children who were present, ran out of their room to prevent Mr. Garcia from hitting her.
Y mientras él la tenía así tomada, sus 3 hijos salieron corriendo de la habitación para prevenir que él la golpeara.
The officers also spoke with the defendant via the Spanish translator from the language line.
La policía también habló con el acusado a través del intérprete de language line,
who advised that he and his wife did not get into a physical altercation, it was only verbal.
que dijo entonces que él y su esposa no habían tenido una discusión o pelea física, sino verbal.
However, the officer spoke with one of the juveniles, one of the 3 juveniles who were present at the location.
Sin embargo, los oficiales hablaron con uno de los menores que estaban presentes en el lugar.
And the juvenile advised that he was uncomfortable saying what the argument was about, but that his parents had been arguing.
Y el joven o el menor dijo que se sentía incómodo de hablar sobre el tema por el cual los padres habían estado peleando.
But the child did admit to the officers that he and his other 2 siblings observed their father holding their mother against the wall with one hand underneath her neck.
Pero el menor dijo que él y los otros hermanos habían observado al padre teniendo a la madre contra la pared, sosteniéndola del cuello.
The child stated that he and the other 2 siblings ran out of their room and got in between their parents to prevent the father from hitting their mother.
El menor también dijo que él había salido, los 3 hermanos, corriendo de la habitación para ponerse entre medio de sus padres para evitar que él la golpeara.
Judge, based on the factual basis of this case and the defendant's criminal history, the state recommends a $5,000 good bond, that the defendant have no further contact with Rocio Morales and the children. And I'll just give the initials of the children. A is in Apple, G is in Giraffe, M is in Morales. Second child, J is in Jaguar, G is in Giraffe, M is in Morales. Third child, D is in David, G is in Giraffe, M as in Morales. Stay away from the location of 1823 Hemingway Lane in Fulton County. The state makes this recommendation, Your Honor, taking into consideration that this defendant is a multi-state offender, that he has a pending DUI case where he was arrested in Roswell, pending here in Fulton County. And we feel that while out on bond, the defendant has a likelihood of intimidating the victim and witnesses. And we are concerned about the facts of this case. Had the children not intervened, this is a simple battery, Judge, but could very well have been a battery or possibly even something more serious.
Lo que quería la Fiscalía declarar entonces que basado en los hechos presentados, en el historial de antecedentes penales que tiene el acusado, queremos pedir una fianza de $5,000, que este acusado se mantenga distanciado de Rocío Morales y de los niños, a quienes voy a identificar con sus iniciales, que son, el primero es AGM, el segundo es JGM, el tercero DGM, y que también, además, la Fiscalía solicita que se considere, debido a todos los antecedentes penales que tiene en múltiples estados, también hay un caso pendiente y también porque esto incurriría en la posibilidad de que él pueda intimidar a la víctima.
And lastly, Judge, of course, the state would ask that the defendant have possess no weapons and consume no drugs or alcohol while on bond.
Y por último, su señoría, la Fiscalía solicita que quede prohibido el uso de drogas, alcohol y armas mientras esté libre bajo fianza.
Ms. Helen?
Yes, Judge. Mr. Garcia is 43 years old and he does reside in the Roswell area.
Sí, su señoría, el señor García tiene 43 años de edad y reside en el área de Roswell.
I just want to make sure I am correct on his history.
Quiero asegurarme de que el historial esté correcto.
He only has the DWI in Roswell, correct?
Él tiene el cargo por con manejar por el efecto del alcohol en Roswell solamente.
And then my current case.
Y en mi caso.
I thought there was a 2004 DUI and a 2005 affray.
Creo que habían dos cargos en el 2004 y en el 2005, y en el 2004 está relacionado con el alcohol.
And the 2004 was out of which state, Your Honor?
¿Y el del 2004 en qué estado ocurrió, su señoría?
I did not record that.
Creo que eso no lo grabé.
Ms. Roberts?
One second, please.
Un momento.
Are you referring to the driving under the influence, Ms. Helen? The
Yes,
2000
whichever.
I show that was out of Roswell, so that would have been Fulton County.
Eso sería en el condado de Fulton, en la ciudad de Roswell.
Roswell Municipal Court.
En la Tribunal Municipal de Roswell.
There's an allegation he was a multi-state offender. I thought I heard that.
Yes, he has arrest out of the state of Illinois.
Understood.
Sí, él tiene delitos cometidos en varios estados.
I do hear the arrest out of Illinois, Your Honor.
Yo veo que hay un arresto en el estado de Illinois, sí, señoría.
However, to address the bond factors,
pero para referirnos a la fianza y sus factores,
he has been residing in Roswell for the last several years with the alleged accuser and his family.
Él ha estado residiendo por varios años en Roswell con la alegada víctima.
And yes, Your Honor, he's from Mexico, but he's resided in Georgia since 2002. Yes, 2002.
Sí, su señoría, él es de México, pero él ha residido en Georgia desde el 2002.
Addressing whether he'll come to all court dates, I believe he will, Your Honor.
Si nos vamos a dirigir si él se va a presentar o comparecer ante el tribunal, yo sí creo que él lo hará, su señoría.
Addressing the second bond order or the bond issue, whether there will be any intimidation towards the witness.
Con respecto a la segunda, la fianza, la cuestión de la fianza, y si podría existir intimidación a la víctima, su señoría.
I do not believe that because Mr. Garcia has been residing peacefully with the alleged accuser for the last 23 years.
En realidad no creo que eso sea probable porque el acusado ha vivido por 23 años pasivamente con la víctima alegada.
Currently, Your Honor, he is also fully employed at the SMP Corporation as a workman.
En la actualidad, él está trabajando para la corporación SMP.
And as you've heard, Judge, he does have 3 minor children that he is one of the primary caregivers of.
Y también, como escucho, ellos tienen 3 hijos menores, al cual él es el primer proveedor del sustento para todos ellos.
Also, Your Honor, when I spoke to Mr. Garcia, he stated that they were having just a verbal argument.
Y también cuando hablé con el señor García, él declaró que solo tuvieron una discusión verbal.
And that there is no history of violence between Mr. Garcia and the alleged accuser.
y que no hay antecedentes de violencia entre el acusado y la víctima alegada.
Your Honor, currently because of his history, we are asking for a signature bond.
Debido a sus antecedentes, su señoría, quiero solicitar una fianza bajo firma para él.
We are asking for a $1,500 signature bond.
Estamos pidiendo esa fianza bajo firma por $1,500.
And if Your Honor feels that he is ineligible for that signature bond, we're asking for no more than a $1,500 surety bond.
Y si su señoría considera que él no cumple los requisitos para recibir una fianza no monetaria, pedimos que una fianza bajo garantía de no más de $1,500.
And Your Honor, I spoke to Mr. Garcia. He does have a separate address to reside at while this case is ongoing for a cooling down period between him and the alleged accuser.
Y su señoría, yo hablé con el señor García y él tiene otro lugar a donde ir a residir para otorgar un periodo de tiempo para que se apacigüen las cosas.
After speaking to Mr. Garcia, he believes the alleged accuser will allow him to come back to that address.
Después de hablar con el señor García, él cree que la víctima alegada le permitirá después de un tiempo volver al domicilio.
So, Judge, we are asking for that signature bond, but we understand that there's a stay away order with that.
Su señoría, solicitamos que le otorgue una fianza bajo firma y también entendemos que puede existir una orden de mantenerse distanciado de la familia.
There are 3 minor children, Judge. We're asking for a third-party visitation with those children.
Debido a que hay 3 menores hijos de esta familia, pedimos que haya se permita la visita a través de una tercera parte, transportando.
And just finally, when I did speak to Mr. Garcia, Your Honor, he would really like to get back to work. He is worried that he will lose his job if he is not released on that signature bond.
Y también después de haber hablado con el señor García, él realmente quisiera poder volver a trabajar. Está muy preocupado en que pueda perder su trabajo y necesita salir bajo esa fianza bajo firma.
Thank you, Your Honor.
Gracias, su señoría.
Okay, it's going to be $1,000 good bond. No further contact with Ms. Morales. Stay away from the Hemingway Lane address. He can go back to that address on one occasion with law enforcement to retrieve any belongings that he might have there. There'll be third-party transfer of the children for visitation. No drugs, alcohol, or weapons while out on bond.
Entonces, dictamino que haya una fianza de $1,000 bajo garantía, que no tener más contacto con la víctima, la señora Morales, que se mantenga alejado de la dirección del 1823 de Hemingway Lane, que puede regresar solo una vez escoltado por un oficial de la policía para recoger sus pertenencias personales, y permito la visita con los menores a través de una tercera parte, y queda prohibido durante el periodo de estar libre bajo fianza, queda prohibido el uso de drogas, alcohol y armas.
Anything further for Mr. Tovar Garcia?
¿Algo más para el señor Tovar García? No.
Okay, good luck to you, sir.
Buena suerte, señor.
Thank you, Madam Interpreter. We appreciate it, as always.
Thank you. Have a good day, sir.
Thank you.
Judge Morrow, I have an announcement for you.
Okay,
For positions 4 and 7, they're both medical reset.
okay, so they'll be reset until tomorrow, the 21st.
Yes. And then also for position 22, they waive their appearance, and then we're completed here in courtroom 2.
All right, thank you. I appreciate it.
Thank you, Judge Morrow.
Thank you, Norris.
Okay.
Thank you, McGregor.
I'm Francois.
Oh, sorry.
I was like, I didn't see McGregor there today.
That's cool.
Let's see, position 22, Ricky Williams. That's your case, Ms. Hoag?
No, Your Honor, it's not. I'm sorry, I was just.
Oh, no, that's mine, Your Honor.
So there's a waiver filed.
Yes, Judge.
Okay, is there a history? Ms. Roberts? Do you know, Ms. Roberts, are you with me? Ms. McCutcheon, do you know if there's a history?
Yes, Judge. The state's record shows that the defendant has a total of 45 arrests. As far as his convictions, the most recent conviction was, let's see, Judge, I know. Is this the last case? He's waived his presence. So is the courtroom empty there at the jail? Okay. So Judge, he has a September 21 conviction for public indecency, sexual battery, and obstruction. That's in 21 SC 178698. He has a December 2nd, 2019 criminal trespass conviction from MARTA. That's 19 CR 009827J. He has a October 2019 possession of cocaine conviction, 19 SC 1864621. He has a November 9th, 2016 conviction for public indecency, 16 CR 011690J. He has a NOLO criminal trespass from 2016 out of DeKalb. He has a January 17th, 2016 public indecency conviction, case number 16 CR 000607J. He has a August 2015 criminal trespass and obstruction conviction, 15 CR 009846. And as for judge for arrest, he has numerous other arrests. Those are his convictions. He has numerous other arrests. The most recent arrest the state shows is from January the 28th of this year at MARTA, January the 18th, criminal trespass, January the 18th of this year, again, criminal trespass, MARTA, January the 11th of this year, criminal trespass, Doraville, October the 24th of 2022, criminal trespass, MARTA, September 26th, 2022, criminal trespass, MARTA, and September the 9th of 2021, criminal trespass and obstruction, Atlanta Police Department, so Fulton County. And then judge other public indecency pending arrests from 2021 on MARTA, as well as pending criminal trespasses, a 2015 public indecency arrest, no conviction, various others, as I said, Judge, totaling up to the total of 47 arrests, Judge, for the 45, I apologize, 45 arrests. The state would expect this case evidence to show that this is yet another criminal trespass case, Judge, from MARTA, the Bankhead Station, February the 18th of 2023, when the officer was dispatched to that station, unknown black male on the train tracks without proper authorization. His clothing was described. Officer arrived on scene, saw an individual matching that description and that clothing description as well. The defendant was then handcuffed and transported without incident. The officer was able to verify that the defendant has a permanent ban from MARTA effective October 20th, 2021. The state recommends, based on the aggravated criminal history the state would submit to the court, the state recommends a $7,500 good bond, that the defendant stay away from all MARTA transit facilities, that he comply with the permanent ban that was issued on October the 20th of 2021. And since that date, Judge, he has at least 4 criminal trespasses from MARTA since he was permanently banned. That is the recommendation that the state makes to the court.
Thank you. Ms. Helen?
Yes, Your Honor. Mr. Williams waived his appearance, but I've actually seen Mr. Williams on a SAP calendar. He's homeless. He's residentially challenged. He's been so for the last several years, and he has these reoccurring criminal trespasses, I think with MARTA specifically. I've spoken to Mr. Williams on previous incidents about Gateway, about food or a bed through that program. I do believe Mr. Williams Jr. has that information. Whether or not he's able to attend Gateway or accepted by Gateway, I don't know if that's happened or not. But for the $7,500, even given his history, I think that's really high. So, Judge, we'd ask for a bond no more of $2,000 surety.
Okay, well, I don't think that he could even make a $2,000 surety, probably, Ms. Helen. I do want to see him back with a social worker when he comes back, so that we can get him some housing. It sounds like he might be having some housing issues. I'm not sure if he has some mental issues or not, but I do recognize his name. I think that he has been before me before. So it's going to be $1,000 good bond. I'd like for a social worker to visit him to see if we can get him situated somehow. No, stay away from MARTA, of course, and no drugs, alcohol, or weapons while out on bond. And if you can, I doubt if he gets out, but I'd like to at least have a social worker update me at the SAP calendar.
I'll send that request today.
Yes, and what was the bond again, Judge?
It's $1,000 good bond.
Okay, Judge, and I'll tell you the state's concerned, Judge, because of course with the allegations of, well, not the allegations only, but the convictions for the sexual battery and the public indecency. And I just did a cursory review of the indictment from the most recent, the 21 SC indictment, to make certain that that was a misdemeanor, not a felony public indecency. I see that it was indicted as a misdemeanor public indecency. But of course, the state's concern as to whether or not the defendant is acting inappropriately on MARTA, especially when it comes to women and children. And so whether or not, I don't know if the court would be inclined to recommend any type of evaluation, but the state's very concerned about that.
I do think that he needs to be evaluated. I don't think that even with $1,000 bond that he's going to get out. So I do want to see him back at the SAP calendar so that we can either see what services he needs, and maybe Miss Helen, since he does have other misdemeanor charges,
put those on
if you want to address all those at that SAP calendar with some type of services, I would recommend that, that we try to do that too, since you will have 2 weeks at least.
And Your
Thank
Honor,
you, Judge. And Judge, to perfect the record, it's not just women and children. It is women and children, but it's also any persons that the defendant might victimize by acting inappropriately and unlawfully in a public or private location.
Right. Yes, we don't want him doing that for sure.
And Judge, I'll have two requests for all of his cases to be heard at SAP and for a social worker to come visit him before that date.
Right. And if the social worker, if there's a mental issue problem, then we need to address that. And if there's not a mental issue, I don't know what the issue is. There's obviously an issue. So, okay. All right. If nothing further, Ms. Bridgewater, whenever you're ready.
Yes, I'm ready. Okay, once again, the reset date for the SAP calendar is going to be March the 7th, okay? Position number 1 is going on the SAP calendar with a $2,500 good bond. Position 2 is reset further notice with a total $4,000 SOB through the jail. Position 3, SAP calendar with a $6,000 total good bond. Position 4 is medically reset till tomorrow. Position 5, reset to the SAP calendar with a $3,000 good bond. Position 6, reset to the SAP calendar with a $1,500 good bond. Position 7, medically reset till tomorrow. Position 8 is going to the SAP calendar with a total $2,000 good bond. Position 9, SAP calendar with a $1,500 good bond. Position 10, reset to the SAP calendar with a $2,000 good bond. Position 11 is going to the SAP calendar with a $6,000 total good bond. Position 12, SAP calendar with a total $2,000 good bond. 13 is reset further notice with a $2,000 SOB through the jail. Position 14, reset further notice with a $3,000 SOB through pretrial per judge. Position 15 is going to the SAP calendar with a total $1,500 good bond. Position 16, SAP calendar with a $10,000 good bond. Position 17, reset further notice with a $3,000 SOB through pretrial per judge. 18 is reset further notice with a $4,000 SOB through pretrial per judge. Position 19 is going to the SAP calendar with a total $3,000 good bond. Position 20 reset to the SAP calendar with a $1,000 good bond. 21 SAP calendar with a $1,000 good bond. And position 22 reset to the SAP calendar with a $1,000 good bond. Are there any questions, comments, or otherwise?
Not on behalf of the state, thank you.
All right, very good. Well, thanks for spending your day off with me.
I mean, we could have been shopping for linens.
I tell you, apparently President's Day is a day to get a lot of good bargains.
Not today. Okay, everyone have a good one.
All right,
Yeah.
good day,
Judge.
everyone.
Thank you.
Bye-bye.